Now it is a great pleasure to present Boz Zellinger, who is one of our own in North Carolina with NC Department of Justice, presenting best practices for getting experts admitted under Daubert. Thank you, Boz, and welcome.
Thank you for having me. As Dr. Ross said, my name is Boz Zellinger. I'm the head of special prosecutions and law enforcement at the North Carolina Department of Justice. I've been sort of a career prosecutor. I worked in the Wake County District Attorney's Office for about a decade, and then worked as a special assistant U.S. attorney in the Eastern District of North Carolina for a couple of years before coming over to the Attorney General's office. And I got to know Dr. Ross through a case in which she provided some expert testimony. Here's a little disclaimer for y'all about these are my views and not necessarily, I'll give you some radical opinions, hopefully, that are not the opinions of the Department of Justice. But as I'm sure you've learned this morning, and as I'm sure you know already, the North Carolina rules of evidence, and this is the same for the federal rules of evidence, have Rule 702, which says that if a scientific, technical, or otherwise specialized knowledge will assist the trier of fact to understand the evidence or determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion. So, you know, we tell jurors all the time in voir dire and in jury selection is that, you know, there's potential that you're going to hear from an expert. There's someone that based on these things, skill, experience, training, are able to give an opinion. And that's really the essence of expert testimony, is its ability to make an opinion, which doesn't necessarily apply to other witnesses. And of course, here's the Daubert Standard, which is integrated into North Carolina law about 10 years ago. The testimony has to be based on sufficient facts or data. The testimony is a product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case. I really want to talk at the end of this presentation about the third prong, that the application, because I think that there's a lot of appellate risk in that. And a lot of people focus on the reliability aspect of Daubert, but sometimes there's some big issues with the application of it, the application of science to the facts of the case. So here's our first poll question, and this is really going to test our technical know-how. And so essentially, you can read the question, but if you satisfy 1, 2, and 3 of Rule 702, is the testimony admissible? And I'll give you all a couple seconds to answer that. Awesome. So this was a trick question. I was solely trying to troll y'all at the outset of this presentation. So yeah, so it seems like, you know, if you satisfy Daubert, everything should be admissible, but that's actually not the case. You have to satisfy all the other rules of evidence that could be relevant, such as Rule 403 and issues of relevance. And Rule 403 is, of course, the prejudicial aspect, but it also has to satisfy the fit test. And we'll get to that a little bit later. But essentially, there can't be assumptions made in the expert's opinion that render the opinion so prejudicial that that it wouldn't be admissible. So imagine you're sitting there as a judge and you're in a DWI trial, and prosecutors want to put forward an expert that has assumed so many facts that aren't in evidence, and that it would be unduly prejudicial, that they're giving this expert opinion that a potential defendant was inebriated, and maybe they don't have all the basis of knowledge of what happened in the case, or maybe they're assuming things in the case. So there are situations where you could meet all the requirements of Daubert, but the evidence wouldn't necessarily be admissible. And as a practical point, regardless of what side you're on, whether you're a criminal prosecutor or defense attorney or in civil, there's ways that you can mitigate that and make sure that in an expert report you make it clear that there's different hypotheticals that are being posed here. But there are situations where folks can violate the fit test and also cause problems under Rule 403. moving on, so there is not a requirement that you have to have a degree or that you have to be trained in a certain area. I think y'all might have seen a clip earlier from my cousin Vinny, which was shown ad nauseum in evidence classes across our state as a fine example of what constitutes how a trial really works. But if you have practical experience, you can be tendered as an expert. And again, the central question is whether the conclusion is based on sufficient facts or data, whether it's a product of reliable principles and methods, and whether those have been applied appropriately to the facts in the case. And so, drug officer can conceivably be tendered as an expert. A law enforcement officer testifying about the lividity of a murder victim's body can be used. You just have to be very careful, though, as a practitioner on trying to go too far with an expert, because you've got to make sure that there's notice given. You've got to make sure that all the evidence has been provided to the expert, and founding their expert conclusion is provided, and you have to be very clear and transparent about that. And so those are some problem areas that I think can arise when you go in front of a judge to attempt to prove this. So here's another poll question for y'all. And this is, which of these expert fields have been held to be inadmissible in North Carolina courts? And for folks from other parts of the country, you might have different case law, but I'll give y'all a couple seconds to answer this. There you go. So apparently we do have some North Carolinians here. Polygraph evidence, overwhelmingly the favorite choice and overwhelmingly correct. Eyewitness identification seems like a kind of squishy field sometimes, but there's a lot of social science data that shows that that there are flaws in eyewitness identification. Of course, North Carolina recently went through that in changing the law surrounding eyewitness identifications and the procedures that have to be followed by law enforcement. Drug code words has been held admissible in wiretap cases. It's a rare defendant. It's a really dumb defendant who speaks and says, well, I'm bringing this fentanyl or this cocaine into your area. When do you want to pick it up? Typically, there's drug code words that are used, and a lot of best practices are to get experts, law enforcement experts, to be able to testify that in their experience over monitoring all these wiretaps, there's certain code words that are used that are consistent. Polygraph evidence, though, has been universally rejected by our state. It actually happened in North Carolina prior to becoming a Daubert state, where our Supreme Court held that polygraph evidence is inadmissible because of the inherent unreliability of polygraph tests. There's a litany of different expert fields that have been struck by our appellate courts, and there's some that have been upheld. And there's a variety of different sciences that have been brought before our courts, and there's more and new ones coming forward in the future, especially in the world of digital forensics. I actually had a trial when I was in the DA's office here in Wake County, which is Raleigh for folks outside of our area, where a defendant had committed a murder where they had just cleared a lot of forest to build a Sheetz gas station. Which is something that is a very consistent thing that is happening in our area as all the trees are being cut down. And so when you clear cut, natural area to build a gas station, what happens in North Carolina is you have this red clay, and the red clay has mica in it. And I actually called a geologist to come in and testify about the different kinds of mica. And if you look at a map of this area, there's different kinds of mica found in different parts of Raleigh, just based on the geological record of how the area developed. And so this expert got on the witness stand, and this is something that had never been done before, because there's not a lot of time where we've used geologists, but we were able to seize the defendant's shoes, and the defendant's shoes had this red clay that contained this mica that was consistent with this North Raleigh area and was inconsistent with where it was in South Raleigh. And so, of course, there's a bunch of other, you couldn't narrow it specifically to this location, but it was consistent with this location. And it was just a small piece of the puzzle that was helpful to convict this defendant. And so one practical point that I'd add to this presentation is make sure that when you're presenting expert testimony, whether it be in eyewitness identification, whether it be in geology or drug code words, you've got to make it palatable and interesting for the jury. So, if you're a scientist, you've got to think about how you're speaking to someone who might not have a high school degree, might not have a college degree. Our juries in this part of the state, have folks with graduate degrees who work at, tech companies. And then we have folks that never completed high school. And you've got to be able to talk to both of those groups of people. And so you really have to, as a lawyer, you really have to be able to understand the science so you can break it down. So when your expert starts nerding out, which I think is a legal term, you can dumb it down a little bit for the jury and break it down for the jury. In this case that I'm referring to with the geologist, we had a geologist talking about graphs about the chemical composition of different kinds of mica, which was like instantly made the jury go to sleep. So you really got to spice it up. I ended up passing out to the jurors a piece of mica, which was tremendously prejudicial, because if you've ever held mica, it's kind of sticky and it gets on your hands. And so everybody's thinking, oh, well, that's how it got on the guy's shoes. So these are some of the things you can do to try to like spice up your presentation and make it more interesting, because without it, if you just have bland science that folks don't understand, they're going to check out. And when it comes time for them to evaluate the expert's testimony, when they go to deliberate, they're going to have a hard time doing it. And I think the natural inclination for folks when they don't understand something is to just kind of disavow it. So if I can move my slides forward here. Most of the time, an objection to an expert's testimony comes up pre-trial. And federal court, it obviously has to come up pre-trial. In North Carolina, it really needs to come up pre-trial. And it usually comes in the form of a motion to strike or a motion in limine, or just an effort to exclude the witness when the state attempts, or whatever party puts a witness on, tries to overcome the Daubert thresholds to be able to prove the case. One thing that you might want to think about is that if you're putting forward an expert, if you're the proponent of expert testimony, realize that every area of the expert is going to be examined by opposing counsel. And that means the expert's Twitter feed, any public statements they've made, any testimony they previously provided, people are going to dig into the expert. And so for the experts that might be on this, any scientists that might be on this, just recognize that if you make, bold statements about science or bold statements about the criminal justice system, you might get asked about those if you're called as a witness. When the criminal courts of our state sort of shut down during COVID, our state, North Carolina, had sued Juul, the e-cigarette manufacturer, and I tried to help out with the trial preparation for that case, which involved a lot of expert testimony. And I learned a lot about that from the civil context, but that's especially true in the civil context. If you're facing a deposition, you're going to be asked a ton of questions, not just about your conclusions, but also about anything that could show any element of bias. So after a motion to strike comes up, recognize that also, and I think y'all went over this in the last session, but Como-Tyer, of course, says that Daubert can apply to non-scientific testimony, people that aren't necessarily, that don't necessarily have degrees or established scientists, but somebody who just has a basis of knowledge about science or any other field can come up. A lot of times this comes in digital forensics. We'll talk in a second about a digital forensic case that I had in which an expert was excluded, and the appellate courts had a big issue with that. And that case was this Brad Cooper case, which was, I just included this slide just so y'all could read a little bit about Cary, North Carolina, which is a suburb of Raleigh. And it's described as a futuristic Pleasantville, which I really enjoy. But it's a very affluent area that has just grown massively. At the time of this article, which was from many years ago, it's said that it's swelled to 40,000 people living there. It's now like 127,000 people live in Cary. It's a booming town. Just everything about it's very manicured. There's a sort of a domestic violence homicide that happened with this family that came from Canada, in which the victim, whose name was Nancy Cooper, was in just a horrendous custody dispute with her husband. They were about to get divorced. She was trying to stay in the house so as to avoid losing the house as an asset. They had 2 young kids. One night, she came home from partying, and the next morning she was missing. And this started this citywide search for her because no one knew where she went. Her husband claimed that she had gone jogging and disappeared. That was later proven to be absolutely false. But he worked at Cisco, and he was a phone engineer. And this is back in 2008. And so basically, he fabricated phone calls from her phone to his phone, which is not that hard to do now, but back then was pretty cutting edge, to show that she was alive after he had killed her. And he took her body and dumped it in a rural area. And so in trying to prove this case, we were using all sorts of experts. We used ornithologists, which I believe are like bird experts, to try to show that a random neighbor where this body was found had seen buzzards or vultures flying around. And so that kind of showed that she had died earlier on. We also used an entomologist who's from NC State to talk about the larvae that have been deposited on the body. And by doing that and taking bugs off the body, you can show how long the body had been there. But none of this was very conclusive. The science on this wasn't very conclusive. It was just sort of ballparking when she had died. We also had all the circumstantial evidence in the world that these two folks absolutely despised each other, and the husband was very angry and had an affair and really wanted to get rid of Nancy Cooper. But the biggest break in the case came when the defendant's computer was seized from his house. And we ended up giving it to the FBI to be examined. And on the computer, this is where the victim's body was found. It was this area where they were building a subdivision, which ironically is very close to where my child goes to daycare now, which freaks me out a little bit. In this subdivision, on one of these cul-de-sacs, her body was essentially left there before the subdivision was built. Well, the defendant had looked at this area on his computer, and that was huge for the jury. So just as a sort of practical point, whenever we showed maps of the area where the body was found, we used these maps from back in 2008 when this area was sort of like this. Now there's all these houses. And so the jury had seen these pictures of this map over and over and over again. Every time we talked about the crime scene, they saw these pictures over and over again. Well, then we found these files on his computer that were these little tiles that were in the defendant's cache. And this sort of evidence was pretty new to our trial judge. The trial judge didn't necessarily know a lot about how Google Maps worked, and that it's essentially comprised of different tiles, and as you scroll, the different tiles move. And so we had to get a lot of expert testimony to sort of be able to show this to the judge, to be able to get this in. And so we had all these individual tiles that are found on the defendant's computer as he's browsing prior to killing his wife, which is kind of a big fact. And so we were able to show that all these tiles were found on his computer, these little images. And then when you put them together, it resulted in showing exactly where her body was placed. And so the practical point of this is that this was really compelling evidence for the jury that they could understand because we broke it down so well with the expert witness. This case actually occurred months before North Carolina became a Daubert state, and actually got sent back on appeal because the defendant had an expert who was testifying about his version of the computer forensics. And in his version of the computer forensics, he actually did some things wrong, didn't do it in the most forensically secure way, and then actually admitted from the witness stand that he was not, in fact, an expert in this. And so the judge sort of felt like his hands were tied, and did not allow him to testify as to an opinion about the most important evidence in the case. The North Carolina Court of Appeals ultimately came back and said, look, the judge does not have a gatekeeping function under Frye. And we're not yet a Daubert state. The Daubert codification of the law was in the process, basically. And so it ended up coming back on appeal, and he ended up pleading guilty afterwards to second-degree murder, which was very frustrating. So in looking at Daubert and establishing whether evidence passes the Rule 702 relevancy test, again, will it assist the trier of fact and does it fit? And that fit question is, again, is there evidence that's being put into the expert testimony that makes it fit with the other facts in the case? And so that relevancy test, you might say, well, of course it's relevant. If some party wants to put it forward, it's relevant. But there's a higher burden to get over there. The next question is sort of whether the witness is qualified by expert or knowledge or skill, experience, training, or education. Again, that's something that you're really going to have to build up through your expert report. In the world of digital forensics, in this Jewel case that I did, we were presenting evidence about age gating, which is how a website is able to gate minors from being able to access that. And there's not a college degree for that necessarily. So you're going to need people who work in that field. And so just recognize that when you put an expert on who's not necessarily somebody who's has a degree in a certain area of science, you're going to have to build this up, and you're going to want to sort of buffer their experience and really detail their experience to show that they are in fact qualified to do this. And talking about an expert report, you also want to think about what sources of information you're giving the expert. I recently had a murder trial in which the defendant's mental capacity was really at question, and it was an insanity case. And the defendant fed his expert a tremendous amount of inadmissible evidence that otherwise would not have come in. But because it was relied upon by the expert in making the expert's conclusion, the jury got to hear about it. They were instructed by the court, you're not to take this to determine the truth of what's contained in it. You're solely to use it to determine how the expert relied on it. But of course, once the jury hears that, it's very hard here's the evidence. It's really hard to assume that they're going to put it out of their mind. And so I would really focus on, in terms of an expert report and breaking it down, I would really focus on the sources, make sure that it's clear the sources of information that are provided to the expert. You want to give as much information as possible because you don't want to look like you're cherry picking what information you give an expert, because on cross-examination, if the expert's asked, oh, you weren't shown this, you don't even know about this, would this change your conclusion? Like, that's a good way for the weight of that evidence to be rendered useless. So any background information is important. Interview observations, if it's in the mental health field, or their observations of the facts, making sure you record it very, very well about what happened. In a case like that murder that I was discussing, the mental state of the defendant at the time of the offense is important. Any collateral information that was gathered, you want to make sure that everything is codified in the expert report so that it meets the requirements of science, basically. I mean, I'm no scientist, but you don't want it to appear subjective. You want it to be such that another scientist, if they came along, could take the same information and replicate those same results. And then, of course, you might have a motion in limine about the expert report, which is an effort to try to exclude that. And just recognize that that you're going to have to be able to defend against that and anything in the expert report, and it might be redacted. And so you want to make sure that you really are thoughtful about not putting too much in, because if it gets redacted, it could really hurt your expert's ultimate conclusion. So moving on, the three-prong reliability test. Yeah, I'm sure y'all have already talked about this, and we'll talk about it more. I want to talk a little bit about the applicability that's at the end of this, and then satisfying the other evidentiary rules. We just talked about this a little bit, but all the different sort of things about diagnostic impressions, conclusions, you want to make that very clear in the expert report. Remember that the burden is going to be on the party that's putting the expert forward. So make sure that you are armed with enough information to get past all these thresholds. The next sort of issue I want to address with y'all is the voir dire hearing, the evaluation of whether the expert will be qualified to testify. In federal court, this might happen in a pretrial hearing. In state court, it might vary on your state. In North Carolina, most of the time this happens during the trial. And the question that you might want to ask yourself is, do you want the jury to be present there for it? So if I'm the proponent of the expert, it's really a question of whether the opposing party wants it. But if I'm the opposing party, so say there's a defendant's expert, you've got a really tough question on whether you want the jury there, because you're going to ask the expert all these sort of damning questions in an effort to prove that they don't really know their science and it's not really reliable and they're not really qualified. And you might do all that, and at the end of it, the judge might say, well, yeah, great, that really goes to the weight, but now the person is going to be qualified as an expert. And that's kind of a slap in the face in front of the jury, rejecting all the things that you just argued. So sometimes you might want the jury not to be present. But at the same time, if you do that, the expert's going to have heard all the cross-examination already. So it's a really tactical decision where you really need to think about, am I going to be able to exclude this person? And if not, do I really want to use all my good cross-examination on them prior to the jury hearing it? Because that's something that's really going to go after the weight. And you know, in every state, the expert jury instruction might be different. In North Carolina, it's an expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have specialized skill or knowledge. And the judge will tell the jury, you are the sole judges of the credibility of each witness and the weight to be given the testimony of each witness. In making this determination as the testimony of each witness, you should consider, in addition to other tests of credibility and weight, the witness's training, qualifications, and experience or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, and whether it's reasonable. And so, you know, have that in the back of your head if you're a practitioner about how you're going to go forward with this, because that's ultimately what the jury is going to look at is in adjudicating the weight. So I want to talk a little bit about another case that Dr. Ross was our star witness, and it was this two defendants named Grant Hayes and Amanda Hayes. Grant Hayes was this very popular like singer, musician in Raleigh, and performed at a lot of bars downtown. He had an ex-wife / girlfriend who had 2 children with, and they're in the middle of a horrendous custody dispute. You notice a trend in these murders. I feel like we need to have a CLE for the family law bar about trying to make sure that their clients stay away from people who are abusers. But anyway, it was a very aggressive sort of custody dispute, and the young woman who was a victim in the case, her name was Laura Ackerson. She went over to Grant Hayes's apartment, and then she disappeared again. Citywide search, no one knows where she is. And what had happened was Grant Hayes and his wife, Amanda Hayes, had killed her and then cut up her body, put them in coolers, and driven her to Fort Bend County, Texas, which is sort of west of Houston, where Amanda Hayes' sister lived. They got there and asked some of the Amanda Hayes' sister, that's where they took the body, to Grant Hayes' sister-in-law's house, if there was any alligators in a creek nearby. You can tell where this is going. They eventually dumped her body in this Texas creek, and they obviously had a head start because, you know, no one knew that Laura Ackerson was missing until several days later. Raleigh police detectives went down to Texas, met with the sister, figured out that the body was probably in the creek, called out the Houston Police Department dive team, who came out and dove in this murky, hot water. It was like 105 degrees when they were out there. And we're actually able to recover parts of Laura Ackerson's skull, parts of her torso. I think there was a femur that was found. And it was like, well, great, we have this tremendously desiccated body. There's a lot of circumstantial evidence to show that this defendant did it. But how are we going to be able to really prove this case? And so we called in an expert from NC State, Dr. Ross, who y'all have met. And this skeleton was actually part of our expert testimony in that I have this distinct memory of when Dr. Ross was on the stand, our investigator carried this skeleton into the courtroom, like in his arms, like a baby, and sort of hung it up so we could talk about all the different places where this dismemberment had happened. Through some other investigation, we were able to recover that this defendant had gone to a Walmart at Briar Creek, which is just sort of a Western little shopping center in Raleigh, and at 2 o'clock in the morning had shopped for a saw, plastic sheeting, goggles, and bleach. The Walmart witness testified as well. I could have tendered her as an expert in weird things that happen. But she ended up testifying and about the saw that was purchased. So we had a potential saw and we had parts of the body, and we used Dr. Ross to be able to show that the saw marks were consistent with this saw. And so this is the kind of thing that we're showing. This is very hard for the jury to discern. And so we had to really break down Dr. Ross's testimony to show that they actually bought a pig. We're known for barbecue, obviously, in North Carolina. We bought a pig, and apparently the bones of the pig are a good proxy for human bones. And we're able to saw into the pig and show that the marks made by the suspected saw blades were consistent with the marks made by the saw that was used, that we believed was used in the homicide, which is really sort of putting the nail in the coffin of this defendant. So I'm going to run a little bit low in time, so I'm going to try to get through some of the expert admission questions that you used to ask, and this will be helpful for the practitioners. And here's some of them. But occupation, what do you do? And you really need to break down what it is that they do. If they're a social worker, you need to break down what they do as a social worker. If they're a scientist, if they're a digital forensic expert, if they're a geologist, break down how they know what they're talking about. Get in their present position, their education and training, their background, any sort of licenses, certifications, publications, expert qualifications in other courts, I think is very helpful if they've been previously qualified. If you're doing something on the cutting edge, then they won't previously have testified, but you can build up that they know what they're talking about and that their science is reliable. Another thing is practical experience. If you're dealing with Marissa Tomei from My Cousin Vinny, how they know all these things. Also, any publications that they've done can be very helpful. And again, these are the sort of Daubert standards, but remember that you really need to break down what it is that the person does. If it's bite mark analysis, which has had a lot of litigation about it, or hair and fiber things, you need to really get into with the jury so they understand the sort of parameters of the person's job. And then ultimately, when you're going through that, you want to ask questions that build out, not just what the person does, but how the procedures work in their lab, or how they came to these conclusions, how they can be replicated. Is it verified? Is there peer review done? What sort of confirmation is done? How do you ensure accuracy with these sorts of sciences? And that's really going to get you over the reliable principles and methods threshold. How long they've done it. If it's a brand new science, there's a expert who's testified for the defense in some cases I've done, who's an expert in QEEG, which is this like science of, I'm not going to call it science, method of measuring brain waves to determine if folks have some sort of brain injury that can mitigate their crime. And the analysis of the brain waves, in my opinion, and in every court that I've faced this expert, has been that it's not credible, that the evaluation of the analysis is really a problem because it's not an established science. And there's been some big questions about it. And so those are the kind of fights you're going to have in court, and if you're trying to put on that testimony, you need to show that the analysis is very reliable. After you do that, the other question is the application. The witnesses apply the principles and methods reliably to the facts of the case. We've had in North Carolina recently a couple cases in which folks have attempted in child sex cases, for instance, in an effort to not bolster the victim and have the expert say, oh, this victim is testifying consistent with someone who's been sexually abused, or the physical findings are consistent. Prosecutors have said, look, I'm just going to get somebody cold who can talk about delayed disclosure and some of the facts of things that they've seen in investigations of child sex abuse and their work at a child advocacy center. And they're not going to apply it to the case at bar because that way we avoid bolstering the victim at all. And that's problematic. You can't do that essentially. You can't have somebody who's just cold. You need to have some element of them applying the facts to the case. I very recently almost ran afoul of this, in which I tried to have an expert know as little about the case as possible because I don't want to be accused of having them bolster a witness. And I almost ran afoul of this third prong. So in order to do that, how did the expert become involved in the case? What was the nature of the request or inquiry? What information was provided to the expert for analysis? Introduce any sort of relevant samples or pictures or anything like that to sort of break up the testimony. With that information, what did the expert do? Walk through the specific application of the science, the procedures, and confirm that it was done in a scientific manner such that it could be replicated. And then explain the results, quantify, show, discuss it. What did it reveal in this particular case? Follow-up analysis, was there any sort of peer review to it? And then any other relevant questions that are necessary to show sort of how the analysis and testing was done in this case. And then in terms of the conclusion, there's a lot of times in DWI law and in our state, there's very rote language that's used by everybody. You don't necessarily have to phrase everything the same way, but you need to be very careful about it. I think the last person talked about, saying something is a match. Science is always evolving. I have a MAR, a motion for appropriate relief from 20 years ago where the science has changed. And so you want to be able to show that there's a confidence level, that there's some room for error or probability or whatever it may be, so that it's scientifically based and that there's not any problems with sort of over vouching for the evidence. You can have charts, you can break it down with other sort of breaking down like a final report into a different way to be able to summarize it. You can also do hypotheticals because again, an expert can talk about any sort of hypotheticals and answer any conclusions. And so I want to get to the last poll question here, which is, if a party in a criminal case seeks to introduce forensic evidence from questionable science, but there's no objection to it, can a judge exclude it? So again, so you're introducing some weird science that no one's ever heard of, and the defense attorney is asleep at the wheel, or you're the other party, and the judge says, "Well, I'm concerned. Can the judge exclude it?" And let's go ahead and see the answers. Yes. So that's actually true in most states, but there's a split. So in some states, if you're from West Virginia, Kentucky, Wisconsin, or the 10th Circuit, the judge can't interject sua sponte. So if there's no objection, it's coming in, even if the judge doesn't end. The First Circuit says, yes, a judge can exclude it. Wyoming is another state. North Carolina, there's case law that really states that a judge probably has that gatekeeping function, even if the other party doesn't object. There's a State v. Hunt case in which a fire department investigator testified that an accelerant had been used to set a fire, but had never before been qualified as an expert, and the defendant didn't object to the testimony. As we run low on time, the one other thing that I would mention to you is there's been a lot of litigation about different areas of expert testimony. And when you get to those areas, I would be very cautious about how you proceed. And I would do, if I was the lawyer in the case, I do a lot of research on it. And those are like firearm experts, bite mark, microscopic hair. There's been a lot of litigation about that. And the worst thing that could happen is that you get a conviction or you prove your case or you get a not guilty and the science that it was based on is revealed to be flawed in a couple of years. I mean, that is the prosecutor's nightmare. There's a huge difference between you can't exclude the potential that this bullet was fired by that particular gun, and this gun and only this gun could have fired this bullet. So just be cautious and thoughtful, because as I told you about that State v. Cooper case that I prosecuted, the worst thing that can happen is that you run afoul of the law and have to try it again. And so with that, I think my time is close to up. But I'd be happy to answer any questions that anyone might have, or talk about Dr. Ross's testimony and how cool she was.
Thanks, Boz, for that. Actually, I have a question for you. I testified in that case, right, pre-Daubert for our state. So how would it change, like, since I went up pre-Daubert, and how would it have changed if we had gone after the Daubert ruling?
Sure. So I don't know that it would have changed much because I think even if you're a FRI state, you still want to make sure that you have, even though you can show that a potential expert is in a better position than the jury to be able to explain something, you still want to show reliability and essentially all the prongs of this Daubert analysis so that the jury believes your expert. Even if it's a lower bar, you still want to be able to, the jury to buy into what your expert has to say. And so I've been instructed to stop sharing my slides if I can figure out how to do that. And so that, I think no matter what you're doing or what state you're in, the one question is whether the evidence is going to be admissible. But the biggest question is going to be, you want the jury to believe it. And so you want the evidence to be palatable. And in the situation where you testified, Dr. Ross, we did that by having that skeleton there, so that you can show where somebody's shoulder bones are and what kind of tool marks are made there. Another interesting aspect of that case is that the body in Texas was actually taken to for autopsy in Galveston, and the medical examiner there respectfully did not do my favorite job of distinguishing which parts of the body were cut by the tool by the murderer and what were sort of cut off by the medical examiner. You're supposed to dye one side so it can be much clearer. And so when the body came back to North Carolina, we had to another interesting aspect is we had to buy a plane flight for the body, which is a fascinating endeavor as well. This case was full of buying pigs and plane flights, but our medical examiner here in North Carolina, Dr. Radish, had to sort of figure out what was what before supplying the body to, or the body parts to Dr. Ross to examine.
Yes, thank you. Someone here, an attendee asked, given the varied backgrounds of the jury, how do you recommend expert witnesses testify accurately and understandably to the jury?
Sure. So I think that one of the big issues is you have to make sure that it's palatable, that it's broken down. And I think that really comes from the lawyer. I think that's the lawyer's job in this. You don't want the expert to be so colloquial and sort of talk in a different manner such that you lose other jurors because the jurors don't think that the expert has the expert knowledge. And so I think it really comes from testifying or doing some sort of mock trial before your trial where you go through testimony with the expert to make sure that they're able to break it down. Most experts are smart folks and can talk in a manner that the jury can understand it, but it really is important for the lawyer to break it down. If you're just going blindly through the expert report, you said this, you said this, you said this, the jury's going to fall asleep. And so, you need to break it down by what happened when you got the body. What happened when you got this computer? How did you make the forensic copy of the hard drive? How did you examine the defendant's phone? When you did that, what did you see? How do you codify that? Is this your report? Is this where you put that in your report? The expert report is helpful when the jury goes back to deliberate if they want to see it or you want to use it in closing. But I think it's incumbent on the lawyer to really break it down as you go forward, because otherwise people are just going to go to sleep.
Yes, someone else asked, any tips or suggestions when dealing with technology experts?
Sure. Yeah, it kind of goes back to what I just said. The thing that's really hard is I try cases all over our state, and in certain parts of the state it's very rural, and then you're in the Research Triangle area here in Raleigh, Durham, and Chapel Hill, where if you're presenting digital forensics, there might be somebody on the jury who knows it way better than your expert because they work at some tech company, and so so you've got to be able to hit both those people, the person who has no expertise in this and that person. And so, you've got to make sure that you scientifically get into it and define it when dealing with technology. And then you've also got to be able to break it down. In that Cooper case I was talking about, where the defendant forged or faked a phone call to himself, we had to get witnesses from Cisco to talk about the way that voice over internet protocol telephones work, which is like most desk phones now are those, but and it's like a ubiquitous technology now, but back then it was like, wait, the phone call goes out over the internet, how does that work? And that testimony was painful. I mean, it was painful to talk about it because it just wasn't especially compelling. I'm sorry if I'm insulting anybody who works on voice over internet protocol. But you've still got to hit that and make sure that you do it. And if the jury doesn't find it fascinating, sometimes it's just part of the puzzle that you're putting together. And that's very important. Someone else I think asked, has there been a situation where a jury hasn't been able to understand information based on the information you or the expert has presented? And yes, there certainly have been those situations. And in those situations, you've really got to, I don't worry about that as much as long as the majority of the jury is following along, because that way, when they go back to deliberate, they can talk about it together and say, well, no, I think this really meant this. And so that's why jury selection is the most important thing that a lawyer does. If you're in federal court, it's kind of a free-for-all, and it's much harder. You're ending up with, you don't really know what's going to be on your jury as much, at least in the Eastern District of North Carolina. But that's why you've got to really forge ahead. And another sort of important practice point is to make sure that jurors aren't going to be resistant to expert testimony before the trial even starts. So if you have the opportunity in jury selection, you want to ask about, do you have any preconceived notions about psychology or any element of science? Because, I mean, there are folks now in our world that don't believe in science, and that's terrifying, but they exist and they're potentially on juries. And if you're trying to put on expert testimony, you need to make sure that those people are not on your jury, because you're going to have a really hard time. I mean, there are folks that are, have very strong feelings about psychology or psychiatry, and you've got to make sure that they can listen to the evidence. And that's a motion for cause, really. If a juror's not willing to listen to the judge's instructions and be fair and impartial about it, then they can be excused for cause. But I think if it's just a situation where a juror's just like, I'm tapped out, I don't want to listen to this technology stuff, hopefully, 6 other people on the jury will be able to explain it to them in the jury room. I think another question is, if an attorney introduced an expert witness with new technology in a state that the judge cannot make a decision to overrule the other attorney, what would happen if that trial actually went to federal court? Would the witness be able to introduce the new technology at that time? It's kind of a complicated question, but I think the end result is that whether there's an objection or not, you want to put on enough evidence when you're admitting your expert such that they will make it through any sort of threshold, no matter what lens the appellate courts, in other states, y'all might have, I'm not going to disparage North Carolina appellate courts, but, that they're looking at it through a different lens. And obviously they're not sitting in the courtroom when the person's talking about the technologies or the expert testimony. So I would just make sure that you're qualifying the expert in the correct field as well. That's another issue. You can erroneously try to pare down their testimony, or the expert says, I really do this, and you want to make sure that what they're being qualified in is what is relevant to your case and will get you through that. But I think that if you meet the threshold, you don't have to worry about, no matter what court it's in, what appellate court it's in, the court will find that, you've met the requirements and you can go forward.
So bouncing off of that, I'm just curious, how do you deal with situations of junk science being introduced into the courtroom?
Yeah, so I don't want to disparage anyone, but this junk science that I've dealt with about brainwaves, to have all the 80-page report and pretty pictures and pictures of brainwaves and all this stuff, and the analysis of it, it's just not accepted. And it's been rejected in federal courts, it's been rejected in state courts, but you really have to prepare as a lawyer to be ready to try to take that down. And you've got to be armed with why it doesn't meet the reliability requirements. And that might not just be what the expert in front of you does. If they send it off someplace for analysis, you can't just accept that analysis as fact. And so you really need to dig into that as well. And again, you've got to really evaluate, if you're not sure you're going to be able to disqualify them, do you really want to waste the cross-examination in front of the judge and then have them ready to rebut it when you're in front of the jury? Because again, the jury is going to be your most important party that's going to be vetting this stuff. I guess there's another question here.
Yeah, interesting, because I think that's what happened, but this was from the side of the, oh, go ahead.
No, go ahead.
Oh, we got several questions here. What is your view on consistent with?
I mean, I think it's a good practice. Obviously, people get offended if you're like, this matches. That's awesome that you work in the world of forensic entomology. I think that I don't have a huge problem with it. It's really going to depend on the jurisdiction and the prosecutor or attorney that's calling you. It's a dirty word in that. I don't know. It keeps getting pared down. You know, this is my conclusion. I think it's consistent with this. I think that's fine. You just have to be sure that you're not overly vouching for any of the evidence and not sort of stepping over your scientific bounds. But I mean, I'm sure there's procedures that you adhere to, and as long as you explain those, I think that, you know, with a degree of certainty, this is consistent with whatever, I think is admissible in most of the courts that I've been in.
And the next question is, what to do when the defense asks the analyst to answer with yes or no, and the answer requires an explanation?
I think you object at that point, and everybody should be allowed to explain their answer, and you have to make that clear. And that happens a lot in depositions, but you know, it'll be a yes or no question. You know, is this consistent with blah, 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 and some long hypothetical, and folks should always be able to explain their answers. And I would really jump up and down with the judge to allow that, because the proponent of the evidence is allowed to say, yes, it was the defendant that did this, or yes, it was the, sort of the prosecutor fallacy. The evidence was so strong that that only the defendant could have committed this crime. So I think it's fair for that to be appropriate for the defendant as well, that the examiner or expert should be allowed to explain the testimony. But also, you've got to recognize, like, there's going to be some times where the defense attorney trips up the expert, and you just have to do it on redirect and just really break down. My other practice tip, and I hope that no opposing counsel is listening to this, but like on redirect, for some reason, leading becomes much more admissible. And so you can really lead your expert on redirect to say, like, you were asked this, isn't it true that, but you can really start to sort of get the testimony in the direction that you want to go. And so I think that's a good way to, even if the judge isn't going to stand up and say, no, they're not allowed to explain their answer, you can get them to explain it on redirect. Just make sure that you're taking great notes so that you can do it. And I think there's one other question about the opinion of Dr. Ross. Was the saw identified consistent with, not able to be excluded, et cetera, as to whether the saw was the source of the cut marks on the body? Dr. Ross, I'm going to let you answer the first part of that. I think it was consistent with.
It was consistent with, yes.
Yeah.
And
go ahead. There
were multiple saw blades. So we tried different saw blades. One was, I think, wood blade for cutting wood, and the other one was for cutting metal. And the one that was consistent with was the one for cutting wood. So if you want to dismember anybody, please select that blade, not the other one.
Yeah, and as to the opinion of Dr. Ross, we had a lot of evidence in that case, obviously. I mean, we had video of the defendant literally shopping for the saw blade. Like, that is very powerful evidence to show that it was premeditated and deliberated, that after the fact, he was so thoughtful about which saw blade that he had. But the most astounding part of that was that when they did the cutting of the pig leg, I called Dr. Ross, was like, well, how'd it go? And she said, I don't know, I wasn't out there, because apparently she's squeamish about that or something, which I find astounding because she's dealing with dismembered bodies all day. So that was the most fascinating part of her testimony for me.
Well, does anyone have any more questions? Well, thank you for participating, and thank you, Boz, for joining us today. That was really enlightening. And I think we can move on to our next presenter. And Boz, if you'd like to hang around and watch the rest, that would be great if you have the time.
Thanks so much for having me.
Thank you.